I'd like to thank the committee first of all for the invitation to appear and participate in this hearing and for the nice merienda. House Bill number 4994 seeks to enact the basic law for the Bangsamoro, and I've gone over it. My comments will be concentrated on the constitutionality of these provisions. First of all, I notice that the proposed law recognizes that it is, in its preamble, in consonance with the Constitution. So I think that should lay to rest the concern that the exercise is does not mention the Constitution at all. It's mentioned in the preamble of the proposed bill. Furthermore, I share the concern of Justice Mendoza regarding territory. The territory is part of the elements of the state, where you have people, territory, government, and sovereignty. The Philippine territory is set forth in the provision of the Constitution, and I was one of those who drafted this provision. And we were very careful when we drafted Article 1, our national territory. Now, in this proposed Bangsamoro law, we also define the territory of the Bangsamoro entity. It is in Article 3. I again notice that the provision says that the Bangsamoro territory shall remain a part of the Philippines. So it is not separated from the territory of the Philippines defined in Article 1 of the Constitution. It remains a part of the overall Philippine territory. So it is again, I think a valid provision because there is no dismemberment of the country involved. The other concerns regarding forms of government. I remember when we were in the Constitutional Commission with the Honorable Deputy Speaker, Pamalian Balindo. We were members of the CONCON 1971. Delegate Felix Berto Serrano of Batangas stood up to quote John Milton, who said that on forms of government, let fools and wise men contend, but as for me, what works best is best. It seems to me that this particular exercise now is the product of a long search for a solution to a long festering problem in the province, in the island of Mindanao. As a Mindanaoan, I come from Zamboanga del Norte, and my congressman is here. I'd like to acknowledge him, Congressman Amatong. There are three kinds of people in Mindanao. You have the Christians, you have the Muslims, and you have the Lumans, who are neither Christians nor Muslims. And any entity that seeks to be established in Mindanao should take these three components of Mindanao into consideration. And when we say, therefore, Bangsamoro, it's not limited to the Muslims. It includes the Lumans. It will include even the Christians who remain in the proposed territory. So we have to see to it that they are given equal justice in this exercise, even as it is called Bangsamoro. Before coming here, I checked on my Bouvier's dictionary. Three words: Constitution, state, and nation. Bangsamoro means the nation of the Moro. It is said in the Bouvier dictionary that you can have a state with several nations. A nation is a people with distinct experience and culture. And in the United States, for instance, you have several nations under the U.S. federal state. It includes the 6 nations, the Indian states, including the Mohawk nations and the Seneca nation. And therefore, it is possible for us, in our search for our identity, to have several peoples or nations embraced within one Philippine state. It would seem that this political experiment of establishing an asymmetrical substate in Mindanao is along those lines, to recognize a distinct people, a distinct nation within the Philippine state. So again, I think that is not, although it's thinking out of the box, it's not unconstitutional. The parliamentary form of government, our Malolos Constitution was a parliamentary form of government, although short-lived. I studied it recently because of the Mabini centenary or 150 years celebration, and I noticed it's very similar to the proposed parliamentary government of the sub-state. So it's not something we have not tried before. It's not completely strange to the Philippine experience. Is it unconstitutional? Because our unitary government, national government, is presidential. Would it be unconstitutional for the sub-state to be parliamentary? I don't think so, because what the Constitution requires in the organic article, in the article in the autonomous region, is that the officials be elected and the government be democratic. The members of parliament in Bangsamoro are under the proposed law to be elected by the constituent units. However, the members of the cabinet, being parliamentary, are not elected directly by the people, but they're elected by the parliament. So they're also elected. Election is selection from among the members. So the parliament selects from among their members the cabinet. So that is an election. I think the Constitution does not require direct election by the people, as long as the officials are elected. On the retained powers of the government, central government, it is true that the proposed Bangsamoro bill, House Bill number 4994, enumerates the powers. First, the powers of central government, then the concurrent powers, then the exclusive powers of the sub-state. Nevertheless, the provision of the Constitution must always prevail, and it says there under Article 10, Section 17, this is on autonomous regions, all powers, functions, and responsibilities not granted by this Constitution or by law to the autonomous regions shall be vested in the national government. So that will prevail. There is nothing inconsistent. There are enumerated powers, but we must always have that in the back of these enumerated powers. The Constitution says retained powers shall be with the national government, not delegated. Therefore, it's retained by the national government. Unlike in the U.S., the states retain their powers unless it's given to the federal government. That is the difference there, because they form the federal government. So they retain unspecified powers are retained by the states. In our setup, unspecified powers are retained by the national government. To me, what is important in the Constitution, and this is the flaw in one of the draft constitutions made during the time of error, is who is the Commander-in-Chief of the Armed Forces of the Philippines. That, to me, is the most important provision of the Constitution. And when I asked the drafters, I think it was Selma, who was a member of the ones draft, and your draft, who is the Commander-in-Chief of the AFP? They totally forgot to provide for it. That is a very important provision. Now, in this setup, where we have central government and Bangsamoro, who is the Commander-in-Chief of the Armed Forces of the Philippines? Still the President of the Philippines. There is no Commander-in-Chief of the Armed Forces other than President of the Philippines. So that is a very good provision. That is a very good setup to me. The concerns of the AFP, however, expressed here this morning are very relevant, and we should listen to them. The deployment, for instance, of the AFP within the Bangsamoro territory should be reviewed very well. because the status of forces and deployment of forces is very important in the security of the state. So it should not be diluted, I think. It's very important. The decommissioning also of the Bangsamoro military force should be reviewed very well. We should look into the models of Indonesia and UK as mentioned by Colonel Pobre. Our provision here is something gradual and unilateral. Maybe that should be looked into. Again, what works best is best. Let's see what could be done. This is still subject to changes. These are not written in stone. We can still provide and accommodate the concerns of the armed forces. The provisions on justice, very interesting. There is a provision here that requires the appointment of members from Bangsamoro in the cabinet and in the judiciary. The present constitution requires does not require this. So this is an added qualification. That's the problem. When you say something like this, you add to the qualification of a justice of the Supreme Court, for instance. To be a justice of the Supreme Court, one of them must come from Bangsamoro. That's an additional qualification. That is why we have in Filja, we want only those who take up our courses to be nominated to be judges. But the GBC says that's adding a qualification to become a judge. So they say, we will consider it, but that's not a requirement. Because the Constitution defines the qualifications for a judge. And passing Filja exam is not one of them. So we have to yield. The same will come up with this. Is that adding a qualification to be a justice? And if it is, then it will be unconstitutional. Although it says policy. Again, policy means best efforts. And it doesn't guarantee that it will happen. Bangsamoro should remember that, and he should not complain that if there is no justice in the Supreme Court from their area, that there is a violation. It's just a policy. Policy means best efforts, not all the time. And then, again, as I said, the Supreme Court might declare that unconstitutional for adding a qualification. On the asymmetric, you know that the human body is asymmetric? An alien from Mars who dissects the human body might be misled because when he dissects the head, he sees that the head is completely symmetrical. And he goes down the body, symmetrical, until he concludes, the human being is a symmetrical entity. And just when he says that, he gets to the heart of the matter, he is wrong, because the heart is not symmetrical. So there's a similarity here. They're trying to think out of the box. So we come up with an asymmetrical situation. What does it mean? It's not a mirror image. The substate is not supposed to be a mirror image of the national government. It doesn't have to be. As long as the parameters of this constitution are followed. So as long as you have a democratic government, they are elected, they are answerable to people, and they respect the constitution and national laws, fine, their form may not be symmetrical. Why is it asymmetrical? To suit the culture and the local situation. That is an attempt to redress the long imbalance of injustice in Mindanao. Mindanaoans have always clamored for more attention. There was a time when there were 4 senators from Rizal and not from Mindanao. That's why we wanted a regional Senate. We lost by 1 vote. Because we are always underrepresented. Always Kawawa and Mindanao, Imperial Manila. This is not just true of the Muslims, but even the Lumans and the Christians in Mindanao. So this is an attempt to redress the balance. That is why there is a provision here on transitional justice. That this is not enough. Even if you pass this, hindi pa tapos ang redressing of the long injustice committed against Mindanao. There has to be, some rebalancing that. in order to pay for the long years of injustice. So this is, pagbigyan naman natin dahil talagang aping-aping. But at the same time, there are legitimate concerns. I was, for instance, the author in the Constitutional Commission of the safety clause in the Constitution, which says that in the autonomous regions election, only provinces and cities and geographical units that vote in favor of inclusion shall be included. So if the province of Zamboanga del Norte voted against, even if the entire proposed autonomous region majority says yes, Zamboanga del Norte will not be included. Why? Because the province said no. That provision was accepted by my Muslim counterparts in the control. The Commissioner Alonto accepted it. We talked it over and said that's fair. So that should be followed here. That is a requirement in the Constitution. So inclusion in the Bangsamoro should always follow that principle. Provinces, cities, and geographical units that say no, even if the overall vote is yes, will not be included. That is a safety clause. I think Congressman Lobrigat will have a refinement on that point. On the geographical units, we did not define geographical units. It's up to Congress to define what are geographical units other than provinces and cities. So marami pa akong gusto sasabihin, pero I will just leave the questions. Thank you.